I welcome you all to the 10th seminar of the International PhD in Progress Seminar Series Phase 4, organized by the Global South Network. Dr. Nouman Rayat, I organized this series in my capacity as the founder and chief convener of the Global South Network. I'm chairing the session. I am a lecturer in law at the Leicester Law School, the University of Leicester. My research interest lies within the areas of constitutionalism, judicial independence, the rule of law, constitutional politics in developing democracies. I'm joined by two discussants and one peer commentator. Dr. Ruvi Ziegler, Associate Professor, International Refugee Law, School of Law, University of Reading, is the first discussant. Dr. Ruvi Ziegler is the Director of Postgraduate Taught Programs and co-chair of the LGBT plus staff network at the University of Reading. He is also an Associate Academic Fellow of the Honorable Society of the Inner Temple, Research Associate of the Refugee Studies Center, University of Oxford, Editor of the Reporter and co-convener of the Migration and Asylum section of the Society of Legal Scholars, Senior Research Associate of the Refugee Law Initiative Institute for Advanced Legal Study, University of London, and Editor-in-Chief of its working series. Dr. Tamara Khoury is the second discussant for today's session. Dr. Khoury teaches constitutional law at IE University in Madrid. She holds a PhD in constitutional law. She has been involved in constitutional and institutional reform processes in Libya, Jordan, Mali, Somalia, and South Sudan, working extensively with both institutional actors and civil society organizations, including women organizations. She has conducted research and training and facilitated dialogue sessions for United Nations Development Program, the United Nations Office for Project Services, the Max Planck Foundation for International Peace and Rule of Law, and the Spanish Agency for International Development Cooperation, amongst others. As consultant with the Max Planck Foundation, she is currently involved in South Sudan's permanent constitution making process. Her current professional and research interests are centered on the interaction between democratic support mechanisms and development policy in transitional context. Peer commentator for today's session is Aida Abbashar, who is a Northern Bridge Consortium PhD scholar at the Department of History, Durham University. Her research focuses on the history of constitution making in Sudan, where she looks at the role that different actors, policies, and events have played in constitution development and negotiations since 1956. More broadly, she is interested in Sudanese political history and racialized and gendered discourses in Sudan. She is also a research assistant for the London School of Economics Middle East Centers project titled Understanding the Barriers and Enablers to Women's Leadership in Sudan. Prior to joining Durham, Aida was a social policy officer at the Economic Policy Research Institute, where she supported the government of Sudan and partners in the development of a social protection strategy for the country. Last but not the least, our guest speaker is Ghada Shawgi, who currently is accomplishing a PhD in public law at the University of Cape Town, South Africa. Ghada graduated from the University of Khartoum with a Bachelor's of Law and a Master of Law in 2004. She was awarded the Chevening Scholarship to study Master of Human Rights Law at Queen's University of Belfast in the United Kingdom in 2007. In the period 2009 to 2022, she worked for the United Nations in her role as the Senior Gender Advisor for the United Nations Development Project. She led initiatives to advance gender equality and empowering women in the Kingdom of Saudi Arabia. Before that, she oversaw original UNDP project in Kuwait focused on empowerment of women and their legal rights. In her role as the Gender, Women, Peace and Security Advisor for UN Women in Sudan, she spearheaded efforts to address human rights concerns and to integrate gender lens into the peace process in Darfur. Today, Ghada will present her project titled The Rights of Minority Cultures and Languages, a Multicultural Constitutional Model for Sudan. Ghada, you have 30 to 35 minutes for your presentation, followed by 5 minutes for comments and questions from both the discussant and peer commentators. If time permits, we will then have a 15-minute Q&A session with attendees. The floor is now yours.
Yeah, thank you very much. Thank you for having me. Good morning. Good morning, I think, your time. Good evening, my time, everyone. I'd like to present the thesis of my PhD on the rights of minority cultures and languages, a multicultural constitutional model for Sudan. Let me start by walking you through the contents of the presentation. I'll start by background about the problem. Then I'll go to the research questions. Then I will walk you through the normative framework and then key concepts. I will then look at Sudan historical and political dynamics so as to shed a light on Sudan cultural identity, official policies, and then official language policies. And then I'll discuss with you my comparative analysis that contains different Sudanese constitutions from 1956, the independence constitution, up to 2005 after the comprehensive peace agreement, and then a conclusion. For the problem, Sudan is often referred to as a chromosome of Africa. Why that? Due to the multiple cultural and ethnic groups. And then the majority of the population identifies with Arab ethnicity, that around 51% according to the 1993 census. And this census, maybe it's a bit old, but from my research, I found out that the issue of ethnicity and languages are not integrated in different Sudanese census. So the 1993 was the one that prominent on this side. Also, other ethnic groups include foreign Darfur and Masalit and other tribes, Bija in Eastern Sudan, Dinka, Chuluk, Nuer in South Sudan, Nuba tribes in the Nuba Mountains, Nubian in the far north, and others in the Blue Nile region. The majority speaks Arabic as native language or lingua franca, around 73%. Over 100 Sudanese languages are spoken in Sudan that belong to 3 African language families: Afro-Asiatic, Nilo-Saharan, and Niger-Kordofanian, a subfamily of Niger-Congo language family. Now, Sudan has promulgated a number of constitutions. You will be surprised since its independence in 1956, more than 8 constitutions. The Transitional Constitution, which is the Independence Constitution, 1956, and this constitution has been amended again and reintroduced in 1964 after the downfall of the first military regime. The draft Islamic Constitution, 1968, has been debated in the parliament but doesn't have the chance to be passed because of a military coup again. Sudan Constitution, 85, sorry, the Transitional Constitution 1985, more or less the Independence Constitution with some amendment, and then Sudan Constitution 1998, the Islamic Constitution of the Islamist regime, and the National Interim Constitution 2005 that came as an outcome of the Comprehensive Peace Agreement. There is also the Constitutional Charter of 2019, but this is not within the ambit of my research. While none of these constitutions establish a comprehensive legal framework for the protection of Sudan's diverse cultures and languages, the 1973 Permanent Constitution and the National Interim Constitution 2005 recognize South Sudan's distinct cultural and linguistic identity. With this problem in mind, the research employs a desk-based review and doctrinal research methodology to address the research problem. So the main research question is, what are the features of the constitutional model that can provide appropriate protection for the rights of minority cultures and languages in Sudan? Also, the research looks into two sub-questions. What are the rights of cultural minorities to practice and enjoy their cultures? And what are the rights of minority culture in Sudan regarding the use of their languages? Start by establishing the thesis establishes the normative framework for the protection of minority cultures and languages that is premised on the international and regional human rights conventions. I think I don't need to mention all these covenants. It is in front of you in the screen. And then the protection of minority rights is best described according to this framework as taking a two-pillar approach. So the the first pillar comprises the universal individual rights of freedoms, all the individual universal rights that we know, freedom of expression, association, speech, etc., that are founded, of course, on equality before the law and prohibition of discrimination. The second pillar is the special rights of minorities to preserve their identities, specifically religion, culture, ethnicity, and language. And this thesis looks into culture in a broader term and languages. We'll go on some details. I think the time enabled me to go with some details on the key concepts. For the key concepts of the project, definition of minority. The thesis, I think many of us may know that there is no internationally authorized definition of minority, and a lot of debate around this. So the thesis endorses the definition by Kabertuti, which requires subjective and objective criteria. Mainly numerical inferiority, even if relative, non-dominance regarding political, social, economic rights and status, and self-awareness. And this is very important, I think, the subjective criteria, because for a long time, the South has been the one that are resisting, while the other cultural groups are not really on in the fore, actually striving for their rights and their different cultural identities. Second definition of culture. The thesis also introduces or adopts the UNESCO broad definition of culture, and I think also the United Nations human rights monitoring bodies adopted the same broad definition of culture that entails not only cultural expression, but again, value system, lifestyle, traditions, and customs. Third, equality and non-discrimination. And the thesis looks into substantive and formal equality. Very challenging, actually, to look on the substantive equality. And actually, I've looked at it in my master's, and then again, I unpacked the notion of substantive equality in my thesis. And actually, I argue that formal equality, of course, very important, and equality in law, but equality in fact, equality in terms of redressing the historical deprivation, affording opportunities, and sometimes even affording outcomes or results in terms of, for example, like quota system, positive actions, etc. Fourth point of discussion was, are the minority rights or the obligations towards the state parties negative or positive obligations? So do they require only to abstain from discrimination, or do they require to advance equality? And my argument that they need to do both. And this is very clear, it came very clear in the general comment. Sorry, there is a typo here. It's general comment without an S. Number 23, and the International Declaration of Minorities as well, because it was not a binding convention, yet it helps a lot with setting the standards and also in terms of interpreting the existing standards and conventions and declarations, etc. Fifth, individual rights and group rights. This is also interesting. I've been trying to look into the group rights in the context, in the African context. I specifically looked at the provisions regarding people rights, and if these provisions include minority rights. The question or the argument, not conventionally, but there is some communication from the African Commission of Human Rights of late communications, specifically regarding the Black Mauritanians and their rights in using their language, that may give some glimpse that the African Charter on Human and People Rights tends now to include minorities in its within its scope of implementation. Last but not least, my favorite subject, rights of women. Actually, many frequently refer to women within minorities as minority within minorities, and this is, of course, because of the patriarchal, mostly patriarchal traditions and customs. I looked, the project looked at the leading case of Lovelace against Canada, and you know, the verdict that customs and tradition, I will put it this way: custom and traditions are okay unless it discriminates against their members, women here. I endorse this argument. People may have different point of view, but I endorse this argument, specifically in the context of Sudan, where we have seen the religious traditions, the customs has been used to suppress women. I've lived this myself, not the older generation. My generation and the younger generation, we live this, and we're still living part of it. So is multiculturalism good for women? I would argue yes, unless it discriminates against women. Now let's move to Sudan cultural identity, please. What's the time now? I have 10 minutes. Sudan, as a Arabized Muslim state, emerged during the Fungi Sultanate in the 16th century. The Arabized identity was further consolidated during the Turco-Egyptian colonialism and the Mahdist National Islamic State. The British colonial regime recognized the Arabic Muslim identity of the North while preserving the distinct African pagan identity of the South, where they allowed Christian missionaries to operate in the South, not the North. The nationalist scheme that was active in the post-Second World War, advocated for the independence and self-determination, and was very vocal against the closed district colonial policy, where it segregated the Taus and parts actually of Darfur, but here the focus is the Taus from the rest of the country, for the good and for the bad. The Constitution of the independent Sudan, 1956, was silent about the multicultural nature of Sudan. Nothing, neutral. The identity of Sudan as a monocultural Arabic and Islamic nation has been reinforced by the successive administrations. So while the Constitution said nothing, the administration pushed this strategy. Particularly, I'd argue, I'd name it an assimilationist policies of the military regime of Aboud, where he forced, Islamic institutes to teach Islam in the South without proper discussion with the Southern actors, and also the Arabic language has been forced in these schools, etc., etc. Naturally, the Southern nationalists pushed back, and the war erupted since 1955. On the other hand, the language policy in Sudanese nation state promoted Arabic as the official language, naturally. The Arabic language and culture were perceived as fostering a national unity, actually, because those multiple languages and multiple cultural identities, the thought of the nationalists at that point that the Arabic will be the unifying factor of the nation, and it worked like the language of the nation. Arabic was the language of instruction in the education. This is under the national government and the official language of the national governments. The domain of language maintained the feature of monolingualism in the 1973 Constitution, which declared the Arabic language as the official language of the state, while the identity of the state was defined as Arabic African. So the 73 Constitution that was introduced as part of the the first peace agreement, the Addis Ababa Peace Agreement 1972, continue to emphasize Arabic as the official language for the whole state, while in other terms, it recognizes the distinct identity of the South. Some sort of paradox. Arabic, now I just jump to the Constitution of 2005. Arabic, English, and all Sudanese languages are recognized as national languages under the interim constitution, however, introduces a hierarchy of languages. This hierarchy is very clear in the terminology, in the language of the text of the constitution, the proviso of the constitution, with the Arabic on the top as the widely spoken, given this status. English coming second as the official language of the South and the language of the higher education. All national languages being placed third on the rank because do not afford it any kind of function in the public domain. I'd like to walk you through this comparative analysis of the different constitutions. I put the Sudan constitutions into three categories. First, the monocultural constitution. It's a 1956 constitution with the different amendments in 1964, in 1985. This constitution is based on equality before the law, formal equality, no specific women rights, no Bill of Rights, of course, it is 1956. Recognition of distinct cultural identities. No, sorry, there is a typo here. No recognition of distinct cultural identities. Silent about the cultural identity of the nation. Neutrality, no source of legislation has been identified. It's apparently about the governance system and so on and so forth. So it's centralized governance, but multi-party parliamentary system. So we will see the contrast here. Now the second category, I named it as a dual cultural identity. And this is basically the Constitution of 1973. There is rights and duties, but limited by the law. Women, economic and social rights were very prominent. Actually, that time of many like to refer to it as modernization time. Recognition of the South identity as African identity, and in contrast to the North Islamic Arabic identity. Islamic Sharia law and customs are acknowledged as source of legislation for the whole country. So some sort of legal plurality. Decentralization, the South given self-rule, some sort of autonomy, but the governance system was based on one-party system, some extensive executive power, dictatorship. The third category, multicultural, between two quotes, interim constitution 2005. It includes, bear in mind the framework that we already set up in the beginning. So there is Bill of Rights. The individual universal human rights are there. Also, there is limitation also by the law. There is equal rights for the women and positive actions to advance women's rights. I'd like to say that a big paradox here, because all the laws are discriminatory against women, while the Constitution grants women equal rights and provides for positive actions to advance these rights, but at the level of legislations, mechanism, practices, discriminatory, mostly discriminatory. Now, recognize Sudan as a multicultural state. So there is, the nature of the state as multicultural. The South has its laws based on the customs. This is the multiculturalism that has been introduced. Sharia has a supremacy in this case. Although the South has its laws based on its customs, the national constitution is based on Sharia law, and the national constitution has a supremacy over all the other constitutions, because the interim constitution provides for a constitution for South Sudan and constitution for the other state that never operated, never implemented. But the constitution of the South was protected by the national constitution itself. Last point, but not least, decentralization and asymmetrical federalism, where the South has distinct arrangement in terms of power sharing and wealth sharing. So, based on this comparative analysis, I can argue that Sudan constitutions between 1956 up to 1972 were monocultural constitution based on the Arabic culture and language. During the terms from 1973 up till now, are dual cultural based constitution up till now. Although there is this multicultural feature in the constitution, but in fact, dual cultural identities are really prominent in Sudan constitutions since 1973. Now, to conclude with, the thesis finds out that Sudan has yet to establish a multicultural constitution. We are still in there. Sudan has been in search for the permanent constitution for around 70 years, and now we are still there. We need to establish a multicultural constitution that forms the foundation for resolution of conflicts that revolve around identity and rights and equal rights, identity and equal rights. The thesis proposes these fundamental elements for the multicultural constitution, looking at the convention, of course, human rights standards, but looking at the literature as well. So, so I think the first finding that building consensus around the constitution through a participatory democratic constitution making process. So this has been lacking to a large extent, where most of this constitution has been adopted by military rules, apart from the 1956 constitution that was the nation-state constitution. All the constitution, or most of the constitution in Sudan, has been adopted under military rule with one-party system or two parties sharing powers. So most of the political parties and civil societies, different organizations, and most importantly, the minority cultures and language were not part of the constitution making at any level. Second, we need a transformative approach. Because it looks like we're stuck with the dual identity. After the monocultural identity, Arabic Islamic for the whole nation, then South African, Arabic Islamic North. Where are the rest? Where are the East? Where are the West? Where are the Far North? Where are the Blue Nile? Where are all these marginalized culture and language? Where are they? So this is really, I think it's important that we have this cohesive identity that all Sudanese people, I echo Tariq Madoud here, that cohesive identity that all Sudanese people can identify with. All Sudanese people, including women, girls, and boys, identify with different minority cultures to be celebrated, recognized in the public domain. Languages has to be also, I'll come to the language later. The next element is enshrinement of universal individual human rights. Just a few seconds ago, I told you that the 2005 Constitution has a Bill of Rights, but I think I also made it clear that at the level of legislations, at the level of the implementation, it wasn't there. There were no equal rights. There were no, implementation of the universal individual human rights. So I think this is a very important component. It looks like natural, but it wasn't really there. No discrimination against minorities and non-discrimination against women, openness towards substantive equality, temporary special measures are included. To my surprise, I've seen in the 2005 Constitution a long list of rights for the religious groups, while there is none for the cultural groups, there is none for the lingual group. There is a long list of rights, having their own organizations, having their own charities, having access to the public resources, having access to other public arenas. Last but not least, develop a multicultural language policy. In this argument, the thesis looks into experiences around the globe, but focused on the experience from South Africa, where 11 languages has been acknowledged as national languages. The pros and cons, actually, because while it was celebrated a lot as a very good model, but in Sudan we do have 100 languages, more than 100 languages. We have, let's say, major languages in these blocks: the North, the East, the West, and the South. But we have 100 languages. Some of this language is about to extinct. There is a warning that many of these languages may extinct in one generation or 2 generations. So pluralistic language policies, the thesis argue, is a must. With this, I conclude my presentation. Thank you very much for your attention and for the opportunity.
Thank you, Ghada. Thank you very much for a very interesting presentation. I would like to invite our first discussant, Dr. Ziegler, to share his thoughts on the presentation. Over to you, Dr. Ziegler.
Thanks very much, Ghada, for this really interesting presentation, and I look forward to reading kind of further products as you proceed with your work. And so I had sight kind of just before the presentation of the slides themselves, and I've gone through obviously your discussion just now. So I've got some comments, and I think some of which are kind of in terms of the clarification of the direction you want to go through with your work, and the specific framing, because I think actually there are a lot of different legal questions that this type of work gives rise to, and I think what's important is to, in a way, to choose which are the ones where you think your particular contribution is valuable in. So I will start by saying that I think what you're doing is entirely right in terms of in a way adopting a working definition for things like multiculturalism or for things like minorities, because in a way that is in itself, if you were to contest this, right, if your thinking was, do I agree with this working definition or do I not, that in itself would have been a research project, right? So in a way you can't have too many balls in the air at the same time, and so it's right for you to frame it as this is neither you making the case for these definitions, but it's that those definitions have been adopted by special rapporteurs, as you say, by UNESCO, and that's your context. So that I think is the correct approach given the rest of what you want to do. Now, my first kind of question in a way relates to the different international instruments, because you list four, right? You list the ICCPR, ICESCAR, ICERD, and the African Charter. And I think the first question is, given the very specific, obvious reference to minority rights in Article 27 of the ICCPR, what, as it were, added value do you think you're going to have by looking at those other instruments? And if you're not actually going to, as you were, comparatively assess what the different four instruments do for minority rights, is it really necessary for you in a way to engage them? So because there would be an argument to say, frame your analysis of the different texts, past and present and future, around one working definition, as it were, in international human rights law, which is incredibly useful, right? And that definition, and that kind of takes me to the next point, that definition explicitly references language, religion, and culture. Now, I saw in your initial framework, you were referring primarily to language and to culture, and I think I picked up in towards the end of your presentation that you were saying actually in the 2005 Constitution and more generally perhaps protection for religious rights are more explicit, are clearer than the protection for the other two categories. So if what you're doing here is a choice, if you're choosing to focus on two of the three, as it were, characteristics of minority rights, on culture and language, and not necessarily on religion, I think that's fine. But I think you need to be explicit that that is what you do, and explain why you think the gap, as it were, the legal gap, the protection gap, exists in relation to those two other categories more than it does in relation to religious rights. And that very well may be the case. I mean, you're the experts on the different documents, but I'm just flagging this up as a point. The next point I had is just about framing, and that is on your fifth slide. You have framed the research questions as our questions, right? So what are the rights for women? What are the rights for minorities? Which is a descriptive, type of question. And of course, that's a useful thing to have in any work. It's to set the reader up for understanding what the situation is. But in your fifth slide, you framed your research questions as what are the rights of X, right? So you frame them in a descriptive way. So you're describing to us, to the reader, what the rights are. Now, what I was saying is that it's very important in any legal work, in my view, to actually have a clear analysis of what the legal situation is. But it seems to me from your final slide that you want to take things forward, right? You're not just describing to us, you're not just interested in telling us what the existing rights are, you are interested in as you were, proposing a different path. And assuming that's the case, then I would suggest framing the research questions to reflect this. And then final point, because I know I'm just gonna get a nod in a minute, is just about the scope of your analysis. So in your slide, in one of, I think, your penultimate slide, you did a comparative work of 3 constitutions, 56, 55, and 2005. But you, on an earlier slide, you had other instruments. So I was just, in a way, wondering, in terms of how you want to go about, is your intention essentially to concentrate on those 3, to compare and contrast them, and then to show a way forward? If that is the case, I think that's sensible, but I would be very clear that that is the choice you're making. Thank you very much.
Thank you, Dr. Ziegler, for very useful comments, and I'm sure it's going to help Ghada develop her dissertation. Ghada, assuming that you have noted all the points, may I go to Dr. Tamara, collect the feedback, and then you respond to all these comments together? What do you suggest?
Yeah, good.
Great. So having this said, I invite Dr. Tamara to share her thoughts on the presentations. Over to you, Dr. Tamara.
So thank you so much, Ghada, for the compelling presentation. There are things I had in mind that my colleague Ruvi just mentioned, particularly with regards to the wording of the research question and sub-research questions. In my mind, if what you're looking for is what that constitution might look like, it's more about what it should include rather than what the cultural rights at the moment look like. But let me just take this a step back, and this is a question I have in terms of how you plan to explain your overall approach to opting for a multicultural constitution for Sudan, given the constitutional history of that country, and as you yourself mentioned, the sort of successive failures in adopting a constitution that, well, basically brings about a truly democratic regime, etc. Is the choice of opting for a multicultural constitution simply a sort of attempt at addressing one shortcoming in that long constitutional history that has to do with the fact that cultural rights and linguistic rights have not been constitutionally protected as, say, international instruments mandate? And if so, are you sort of not including at all in that future constitution of yours that would be multicultural in that sense, anything that has to do with other factors that have actually driven past conflicts beyond and perhaps in relation to those cultural identities? And what I'm trying to say is that, to what degree has it simply been about a question of not acknowledging that diversity at the cultural and linguistic levels, and to what degree has it not been a broader socio-economic problem and a question of the sort of ill distribution of natural resources, perhaps coinciding with cultural communities and the geography of the country? I'm just wondering about how you plan to relate or connect Sudan's constitutional history with your proposal, bearing in mind that a multicultural constitution is not necessarily it's probably necessary but not sufficient to address the root causes of past conflicts. So that would be my sort of overall remark. And then very briefly, with regards to the scope, again, I won't repeat what Ruvi said, but I kept thinking throughout that it's kind of difficult to completely dissociate or discuss cultural rights without sort of discussing religious rights. And there are certain inevitable overlaps. And so in my mind, whatever that constitution might look like, and whether you choose to focus only on cultural or religious rights, the question of legal pluralism as a constitutional choice is bound to be addressed. And in that sense, you briefly touched upon this tension between the principle of equality, particularly between men and women, and accommodating both collective and individual, both cultural and religious rights. And so were you to look at that question in particular when it comes to designing a multicultural constitution, I think comparative experiences, particularly in Africa, sadly not so much in the Arab world, Uganda, Kenya, South Africa too, might sort of offer some examples as to how to sort of try to strike a balance, right, between that principle of equality and the accommodation of collective and individual cultural and religious rights, and perhaps, you know, wording whereby dignity is sort of the red line, and that's what Uganda at least has in its constitution, can enable a future constitutional court to strike that balance. Anyway, so that's at the level of legal pluralism as a sort of key component, I would say, of any multicultural constitution. And my last point would be perhaps with regards to the linguistic question. I saw how you kind of, I don't know if criticized, but refer to this ranking of languages whereby Arabic is placed first, etc. And you refer to the South African model as inspiring, and simply based also on past debates elsewhere, including Libya, with its own linguistic cultural minorities. I think the Spanish example is worth taking a look at because they opted for asymmetric arrangements when it comes to the linguistic question. So rather than, instead of opting for example, adopting 4 official languages at the national level, there's this sense, there's this idea, there's this statement whereby Spanish or Castellano is the official language. Every citizen has a duty to know it and the right to use it. But, and this is where it gets interesting, it's asymmetric in the sense that in those geographically, distinct communities where historically languages have existed and ought to be promoted, they are given the right to adopt at their own sort of level, sub-national level, right, their own language as a co-official language beside Spanish. So in that sense, it's not a matter of hierarchy in general terms, it's a matter of accommodating the fact that not every territory within, the state has that linguistic diversity, and allowing that linguistic diversity to be constitutionally enshrined in the sense of a co-official language only where those languages are in place, so to say. So again, just very general thoughts, but in also to specifically address the linguistic question. And I'm sorry if I was long. I'll stop there.
Thank you very much, Tamara, for the useful comments. Ghada, do you think it would be a good idea to collect final comments from Aida before you could respond to all of them together?
Yeah.
Right. Aida, please, over to you.
Thank you so much for a very interesting and important research that you're doing, especially given what's happening in Sudan at this time. It feels a bit strange to be your peer reviewer because you've already done so much and achieved so much in this field already, but I will give it a shot. So I'm also looking at constitution making, but I'm looking at it from more of a social and political perspective. I'm not a lawyer by trade, so I look at sort of a different realm of constitution making. And I just want to start off with the things that really stood out that I think should be expanded upon within your thesis, and hopefully already are, is this first discussion. You talked about ethnicities and languages not being included in the census. I think that's a really interesting lens to approach with your thesis, because as we know, in Sudan, there's been very limited and sometimes even purposeful lack of census building and creation. And so I'd be interested in seeing kind of what impact does that have in the constitutions that you're looking at, this kind of almost deliberate political act to not want to develop these censuses, and the role that also links to the government's intelligence services across different historical periods. Because I think a lot of this idea of trying to suppress multiculturalism in Sudan has been very tactical, right, in various ways. And that leads me to my other point is you mentioned also in your presentation briefly about the colonial roots of like discrimination within Sudan. And I think that's also a really important aspect to expand on. I think a lot can be said that explain how Sudan got into the state that it's in currently, and looking at the colonial roots of that and the divisions, for instance, of like the closed district ordinance and the impact that that had on unequal economic and political development in the south versus the north. And this connects to a comment that Tamara made that I fully agree with, is understanding the social and economic policies that underpin the legal frameworks that create these constitutions. So not to repeat what Tamara said, but something that you could also look at if you're not looking at it already are the education and propaganda policies that were being created across different regimes to suppress again, like multiculturalism, because that was also very purposeful and informed a lot of the constitution making discussions throughout whether that's 1973, specifically also thinking about 1998 as well. And then lastly, I also really liked your comparison between like discrimination versus equality, and the importance to do both, and that it's not just about trying to be anti-discriminatory, it's about being equal. So yeah, I'll just leave it there. Thank you again for your very interesting work, and I really look forward to reading what comes out of it.
Thank you very much. Thank you, Aida, for the comments. Ghada, now you have comments, responses from international law expert, constitutional law expert, and the political scientist and sociologist. This is something which I like about these activities, all these different disciplines, disciplinary perspectives you have now. So yeah, please go ahead if you would like to. You don't need to, by the way, answer. These are the comments. You can note it down. This will be recorded and you can play again and again. But if you want to respond to that, go ahead, please. And those who want to ask questions from attendees, please paste there in the chat box. Sorry for the interruption. Please go ahead.
Yeah, thank you very much, and very useful comments, of course. I'll take note of all of it. Of course, it will be helpful, very helpful comments. But I will go through few of it. Actually, I'll take the question about. Of course, I take note of the suggestion to reframe the research questions. Yeah, very good. Very good comment that I'll take into consideration. But I'd like to respond to the issue of the international framework or the normative framework, because in the thesis, in fact, I focus on Article 27. I use these other conventions in certain areas. For example, I need to use the International Convention to eliminate all forms of racial discrimination, for example, in the area of discrimination on basis of ethnicity and, basis of ethnicity, race, etc., etc. So I use the jurisprudence from these conventions, but all in all, the centerpiece and the masterpiece and the focus was on Article 27. But of course, there is gray area in Article 27. No definition. Is it individual or group-based? Again, positive or negative obligations. So all these questions, in fact, follow from Article 27, discussion on Article 27. But I use these other conventions to put the picture, to frame the picture in the whole, and again to do this bit and pieces that where I complete Article 27, because there is those gray areas, or there is those critiques as well. So this is the methodology that I dealt with the international framework. I hope that I answered this part of the question. Actually, the thesis from day one focuses on the cultural and language rights. Basically, I know it looked like not very logic just to single out the religion from this, because of course, again, as Tamara said, there is overlaps between religion, culture, religion, and language to some extent. But it will be like 3 PhDs. When I started to discuss the proposal, I want to cover everything. But then I realized the real gap on the side on the culture or language, because the religion has been on the fore, the discussion about the religion and state, secularism has been in the fore throughout the history of Sudan. So, and these proposals, I mean, to adopt a comprehensive Islamic constitution, no, pro-Islamist constitution, all this debated there. So I think it's in a way covered, I think, in terms of course, there is a room for new research, but I think, it has been occupying the research in Sudan for many years. While my own investigation, that the language and culture has been sidelined, while it's very important, to the minority groups in Sudan, but it has been sidelined in the legal discipline, And by the way, although there is no proper census, Aida, but the jurisprudence, specifically from linguistic point of view, is there. Because there is a specialized institute in Khartoum University for languages and culture. So there is good deal, I think, of research available in terms of language. But again, the legal voice is missed. And this is what really inspired me to take the language and culture in my thesis. Legal pluralism. Yeah, I think legal pluralism has been discussed in the thesis in details, not like the presentation, because I have 30 minutes to present everything. And legal pluralism has been some sort of legal pluralism in Sudan since, the colonialism. I didn't focus on colonialism per se, because, of course, I have a scope for my PhD, but of course it's an interesting area to look at. But for the legal pluralism, there is some sort, in place, since specifically, again, on the women's rights side, specifically about the family law. And there is a debate in that. Even I personally had discussion with different actors about, should we keep the family law without religious reference, which is impossible actually in Sudan, or shall we go with some limitation that, the same limitation that has been done in other jurisprudence to limit, the discriminatory practices rather than, eliminate all the religious traditions, which is totally impossible. I look on the Spanish example. I don't have a room in my thesis, but I look at it, and of course the discussion about the one official languages, 2 official languages, 1 official languages. There is also other proposals in the arena that English and Arabic official languages, and then regional variant approach, where we can have 4 in the west, we can have Nubian in the south, in the north, we have, and so forth, and so on and so forth. Thank you very much.
Thank you very much. Thank you, Ghada. Thank you, all of you, Dr. Ziegler, Dr. Tamara, Aida, for useful comments. I think in the end, to conclude the session, I found it very interesting because I can see a lot of similarities between constitution making process in Sudan and the constitution making process in many other countries, and that's why these all these activities I conduct, because if we keep on sharing the knowledge, exchange knowledge on good practices on all these activities, I think potentially we can find some solution, hopefully. For example, this constitution making process, the issue of legal pluralism, language, culture, is right now center of the debate in Afghanistan. So what's the constitution is going to be? How we are going to resolve the issue between the Pashtuns, the majority, and the non-Pashtuns? And the same was the case was during the 2010 regime. Ashraf Ghani's regime was the problem. Same issue exists in Bangladesh, Sri Lanka, and all of the similarities. I think the case studies where the constitution was successful or it survived for some time, we really need to see how the interests of different groups converged or different parts of the constitution. I think that's the major pattern I can see on different countries where political groups, their interests converged, or certain provisions or the major provisions of constitution, that constitution work it survive different ups and downs for a very long time. But when the interests are not converged, or some majority group imposes on a lot of different other groups, then it works for some time, but ultimately it fails. Thank you very much. Same time next week, we are going to have another presenter from Ghana, and the details will be communicated to you in the next weekly email. The Global South Network welcomes all PhD students from any parts of the world to present their project in any area of study or life. All you need to do is to send me your abstract and the topic at the Global South Network at lister.ac.uk or leicgsn@gmail.com. Until next week, look after yourself. Have a great day. Goodbye.
Thank you very much, and best of luck, Ghada.
Thanks very much.
Thank you very much. Thank you for having me. Bye-bye.
Thanks for the invitation. Bye-bye.